All right, let's get into this Tory Lanez thing. There's really nothing much. I went through the statement of appealability. I went through the statement of facts. The erroneous admission of evidence, state argument, prosecutor, prosecutorial misconduct, the trial court. The thing with this, the thing with this is like most of the stuff that I read yesterday. This is the same. It ain't really nothing. It really ain't nothing more. Let me see. Okay, wait a minute. Okay, they talk about the text messages here. What part is this? Prosecutors and permissibly argue facts not in evidence. A prosecutor may not suggest, hold on. Give you a little imagery here. Okay. A prosecutor may not suggest the existence of facts outside of the record by arguing matters not in evidence. People versus Woods, quoting People versus Benson, statements of supposed facts not in evidence are highly prejudicial form of misconduct and a frequent basis for reversal. People versus Hill. At trial, Harris testified that just a few moments after the shooting, she sent a text message to Pete security guard Justin Edison stating, "Help. Tory shot Megan, 911." Prior to trial, counsel filed a motion in limine seeking to exclude Harris' text message and other hearsay statements made by Edison. After being informed that prosecutors were seeking a body attachment for Edison, counsel further expressed concern that if the people discussed Edison's expected testimony during opening statement and then Edison did not testify, Peterson would be prejudiced. Despite counsel's objections, the court allowed prosecutors to refer to Edison's hearsay statements. During the people's opening statements, Bott referenced Harris' text message to Edison. Bott then claimed Edison spoke to Peterson the day after the incident. And Edison will tell you that. Who's Edison? Is that Jaquan? Oh, yeah, Justin. And Justin will tell you that Tory admitted much of what he admitted in jail, in the jail call, and in the text. That he was the trigger man that night. That he did that shooting. But again, for the umpteenth time, that he was too drunk and says he was just shooting in the air and shooting at the ground. But more importantly, he tells Justin, he admits Justin that he was the person who fired the gun that night. Mid-trial, prosecutors presented an ex parte application to increase the body attachment amount for the Edison due to difficulties in locating him. According to the counsel, the issue was portrayed in the media as to suggest that the defense engaged in some impropriety to prevent Edison from testifying. During the closing arguments, prosecutors also made unfounded allegations that Harris was successfully bribed or threatened by Tory in an effort to compromise her testimony. We saw Kelsey in court, and something happened to Kelsey. Obvious something happened to Kelsey between that September statement in 2022 and her testimony at trial. Something spooked her. Somebody got to her. Maybe she took one of those bribes. Something happened to Kelsey that compromised her testimony. So why? What happened? What happened to Kelsey between September and this trial? Bott made similar allegations in relation to Edison. Where's Edison or Justice? Right. I told you you'd hear from Edison in this trial. But what did we hear? We heard Tory attempted to bribe and silence Megan. We heard Tory attempted to bribe and silence Kelsey. And we, in fact, saw that Kelsey had been compromised in this very courtroom. Where's Justice? You cannot speculate about where he is. Okay, that's something that I told you you'll hear from that we didn't deliver on. But thankfully, we have the text messages that Kelsey sent to him. There was absolutely no evidence to support the argument that Kelsey and Justice were successfully bribed, threatened, or compromised by Tory. Such argument amounts to pure speculation. Nevertheless, there is reasonable likelihood the jury understood or applied the complaint of comments in an improper or erroneous manner. That, for example, that prosecutors had some special knowledge about purported bribes made to the two witnesses. This especially true where media accounts of Edison disappearance seem to imply that the defense was somehow involved. Yeah, they do got enough for an appeal. I need some water. Prosecutors impermissibly denigrated defense counsel. Denigrating defense counsel, a prosecutor directs the jury's attention away from the evidence and is therefore improper. The People versus Sandoval, and assessing a claim based on denigration of counsel, reviewing courts must view the prosecutor's comments in relation to the remarks of the defense counsel and inquire whether the former constitutes a fair response to the latter. People versus Fry, 1988. Prosecutors denigrated counsel repeatedly throughout the closing argument. While discussing Harris' recorded statement with prosecutors, Bart argued that the counsel tried to mislead and manipulate jurors into believing that her interview was improper. Why do you think the defense wanted you to think, excuse me, why do you think the defense wanted you to think what we did was improper without having you see the full picture? Ask yourself that question, because obviously the interview was totally overboard. I mean, above board. So why do you think the defense wanted to think that it was something before you saw the full picture? Isn't that misleading to you? And ask yourself, why would the defense intentionally mislead you? Why? Because they cannot defend the evidence in this case. They resort into insinuation and manipulation. While discussing Harris' diss track, Bussin' Back, Bot commented as follows, directly inviting the jury to improperly consider their emotions. Why is the defense literally intentionally misleading you about what had said was said in the song or song is? How does that make you feel? Bot then compared counsel's conduct to bribery. Just like the defense in the trial is trying to mislead you and manipulate you into thinking things that clearly aren't true. Tory was trying to put a lid on the truth of what happened in the immediate aftermath. Don't say anything. I'll pay you $1 million. That's been the strategy from the beginning. Silence the witness against them. But even went as far as to imply that smart jurors would not believe the defense theory. For example, in relation to Tory's jail call to Kelsey But argue the defense will have you believe that this call is about a romantic entanglement between Kelsey and Megan. Do you really think that that's what Tory's talking about here? Seriously? We picked the smart jurors here. When discussing the DNA evidence, Bart continued. I asked the expert if the defense attorney get whatever sick is up here and argues to this jury, Tory's DNA was not on that gun. Would that be an accurate statement? No. Don't be fooled by that argument. It is not accurate. He can be included or excluded. But don't be fooled by an argument that Tory's DNA was not on the gun, because that's just not accurate. And we've seen attempts to mislead you. And I don't want that to happen again. Emphasis added. The prosecutor argued in People versus Sanchez, the prosecutor argued in closing that the defendant hopes that one of you will be gullible enough, naive enough, and hoodwinked by the defense argument so that he can go home and have a good laugh at your expense. The People versus Sanchez. The 4th District found that such comments amounted to prosecutorial misconduct because they were designed to offend and intimidate any potential holdout juror who doubted the defendant's guilt. The Sanchez court explained further. By focusing on one of you, the prosecutor's comments were directed at any juror who might consider being a lone holdout for acquittal. The prosecutor planted the idea that anyone who accepted the defense attorney's ridiculous arguments would be a sucker who could easily be manipulated or hoodwinked. If prosecutors' comments had the desired effect, they created a risk that a juror would decide to wait. They would create a risk that a juror would decide the case not based on the evidence or the law, but rather find the defendant guilty to avoid being viewed as gullible, naive, or hoodwinked. None of these statements focus the juror's attention on the testimony or the evidence in the case. Rather, they were made to intimidate any juror who believed defendant's defense and did not want to be laughed at or viewed as gullible, naive, or hoodwinked. The statements could have had a chilling effect on the jury's deliberative process. Deliberative process. The prosecutor in the instant case made similar comments, accusing defense counsel of intentionally misleading jurors by resorting to insinuation and manipulation. These were not isolated comments. Prosecutors questioned why the defense literally intentionally misleading jurors and asked, how does that make you feel? Thereby directly inviting jurors to consider their own personal emotions. These comments were not in response to any remarks by trial counsel. Thus, there is a reasonable likelihood the jury understood or applied the complained of comments in a manner which invited the jury to feel personally manipulated by the defense counsel. See Friend 47. These improper closing comments require reversal. Based on the foregoing, it is clear that the prosecutors made arguments that gave Based on the foregoing, it is clear that the prosecutors made arguments that gave the impression that the emotion may reign over reason, and to present irrelevant information or inflammatory rhetoric that diverts the jury's attention from its proper role or invites an irrational, purely subjective response. Because of the repeated insidious and proper comments, there is a reasonable likelihood the jury understood or applied. Okay, it's an emergency going on, y'all. I hope everybody's safe. Understood or applied the complaint of comments in an improper or erroneous manner. Given the onslaught of the misconduct that occurred in this case, it became increasingly difficult for the jury to remain impartial. No added motion would have cured the harm to these comments because they were based largely on improperly admitted testimony. Given the conflicting testimony and serious credibility issues with key witness, this prosecutorial misconduct could have materially contributed to the verdict. As a result, prosecutors' misconduct infected the trial with such unfairness as to make the conviction a denial of due process under federal law. These comments also constitute a violation of state as they were involved the use of deceptive or reprehensive methods to persuade the jury with improper and the excessive appeals to emotion and sympathy for the victim. If this court finds that the above issues were not properly preserved for appeal, Peterson, wait. If this court finds that the above issues were not properly preserved for appeal, Peterson avers the counsel failure to object constitutes an effective assistant apparent on the face of the record. Because a reasonable attorney under the same circumstances would have objected, counsel performed deficiently, and Peterson was prejudiced as a result. Even if this court finds that these errors were not properly preserved and could have been cured by timely admonition, the weight of the effect of these improper comments pervaded prosecutors' closing arguments. If the trial court reversibly erred, admitting evidence of Peterson's creative expression, a fair trial free from unfair prejudice, racial bias, and improper consideration of criminal based on his gangster rapper persona, his creative expression. I read this yesterday, the newly added evidence. Improper admission of Peterson's tattoos as evidence of creative expression. While examining Officer Sandra Cabral about GSR testing, the people sought to introduce Exhibit 18. A photograph appears to depict Tory at the station or around the time of the GSR swabbing over objections. A sidebar followed. Counsel asking the GSR and showing a picture of my client. There's no relevance to this picture. It only swayed the jury because my client looked like he got tattoos. The court. It's to show who the people are that she took a swab from. I don't see anything wrong. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? The people's actual intent to inject racial bias into the proceedings through Exhibit 18 was revealed during the cross-examination of Eric Culberson, Megan Stiles. After Culberson testified that he had never seen Peterson with a gun, the people asked, now, counsel asked if you ever seen Peterson talk about guns or if you ever seen him with guns. Do you recall that? The people then asked, do you see the big gun that Tory has tattooed on the center of his chest? Peterson's tattoo was neither big nor relevant to the issue at hand. Whether Culberson had ever seen him with a gun, yet the people used the tattoo for its literal truth by equating it to a real weapon to imply Tory does carry guns, as evidenced by the gun he carries on his chest. They got him right there. That is grounds for an appeal because that they wasn't supposed to use his tattoos against him as prejudice, and the way they did it, they wasn't even supposed to. They damn. Therefore, the prosecution explicitly and improperly introduced racial bias into the proceedings. A tattoo of a gun does not mean that an individual has a gun or has ever fired a gun. Nonetheless, prosecutors utilize Tory's tattoo, which is intertwined with his rapper persona, to lead jurors to interpret what is that word? Interpret it as evidence of criminal intent or motive because the gun tattoo could only lead to one conclusion: he is violent, or he is a violent criminal with a prerequisition to commit crimes, since, after all, he is black, gangster, and a rapper. Ironically, Peterson's tattoo was an homage to his idol, Tupac Shakur. That ain't making it no better. Thus, the meaning behind Peterson's tattoo is quite the opposite of the meaning prosecutors designated, in which jurors perceived this type of unfair bias is the precise kind of highly prejudicial evidence that seeks to safeguard against, since the pretensions under 352 too often fall short in cases involving rap artists. Prosecutors' use of Peterson's creative expression as evidence of criminality erroneously throughout the legislative legislative purpose beyond legislative purpose beyond. In light of the aforementioned and under the facts of this case, there is no sensible reason to be interpreted in a matter that excludes tattoos as a form of creative expression. A tattoo suggests that the bearer of the tattoo is highly committed to the message he is displaying by permanently engrafting a phrase or image onto his skin. The bearer of this tattoo suggests that the phrase or image is so important to him that he has chosen to display this phrase or image every day for the remainder of his life. Anderson versus City of Hermosa Beach, due to its permanent nature and mission of Exhibit 18 and the people use of Peterson's gun tattoo against him was arguably even more prejudicial than a video of a rap song lyrics or a rap album cover. Thus, to efficiate the purpose of AB 2799, this court should find that Peterson's tattoo was a form of a creative expression under 352.2 and should have been considered under the standards outlined therein, requiring exclusion. I'm tongue to, I feel like twist over here. That was clever how they did that with his tattoos, because his tattoos wasn't supposed to be admissible in court because they threatened him if he testified for himself that they was going to use his tattoos against him. They was going to use his lyrics against him and stuff to paint the picture that he was violent. He don't testify, and they still use the tattoos against him in a slick roundabout way, which they wasn't supposed to use. The tattoos wasn't admissible in court. But the fact that they did it slick by showing pictures of him when they tested him for the GSR, they was able to use that picture to admit that picture, and then being that picture's admitted into evidence, now they could use that picture for whatever they want. And oh, you see that tattoo of the gun on his chest? And you ever see Tory with a gun? You ever see Tory shoot a gun? You see that tattoo on his chest? That big ass gun. Nigga, that you see how little this nigga is? How big could that tattoo be on his little ass bird chest? Look how little he is. Well, what kind of bird do you think is going on his chest? Tweety? Like a gun, like how big of a gun can you put on his chest? A big gun on his chest, his little body? Like what kind of gun you gonna put on his chest, bro? If you just hold the gun up to his chest, that joint probably a 45 will probably cover his whole chest. I don't know if that's exaggerating. That might not be exaggerating. Look at Megan guns. Look at her biceps. Her guns is bigger than his chest. That is a little dude, bro. Oh, she might have on heels, but Jesus Christ. That's a big girl. let's see, you got improper admission of rap lyrics and rap video. As noted in the comments to the assembly floor analysis, even in cases where creative expressions are not admitted into evidence or are not admitted as evidence, its discussion in front of a jury can poison the well by allowing for explicit or implicit bias against certain forms of creative expression to play a role in the case. AB 2799 will ensure that the creative expression is robustly evaluated before it can be admitted as evidence and ensure that this evaluation takes place pre-trial. In this case, Tory's rap lyrics were improperly discussed at trial and ruled admissible in contravention. P testified, I got to watch Tory drop music videos, chopping up horse legs, and people laughing at it like that's okay. This statement before the jury, Pete, who goes by the stage name Megan Thee Stallion, inferring any references to the stallions and horses may be associated with her, poisoned the proceedings by directing the jury to infer that if Tory was chopping up horse legs in a music video, he was violent enough to shoot her. Pete's testimony implicitly introduced the bias into proceedings because in society, there's always this bias that young black men who rapping must only be saying what's autobiographical and true because they can't possibly be creative. Pete's statements therefore became evidence of Peterson's criminal prosperity or improper character evidence in violation. At trial, the people stated that if Peterson testified, they would use the video and other rap lyrics against him. I just said that. Seeking to admit lyrics of a song where Peterson denies shooting Pete, another song where Peterson lies about his height. The court held that video and rap lyrics related to the case were relevant and would be admissible if Peterson testified. Therefore, any determination, and therefore any determination of reliability regarding this music video or any other rap lyrics was incomplete as it did not comport with the new requirements. So that's the same thing I was talking about, like how they wasn't supposed to put his tattoos. It wasn't supposed to be admissible, and they did it in a roundabout way. They did the same thing with the lyrics when Megan talked about the song that he did with the where he's chopping up the horse legs or whatever. The court impermissibly chilled Peterson's right to testify. We just talked about that. They said if he testified, they're gonna use all this stuff against him, and they used all this shit against him anyway, and he didn't even testify. The jury did not hear Peterson's account regarding the night in question because the court ruled that if he testified, prosecutors could introduce his music, videos, and rap lyrics during cross-examination. Counsel argued that the rap lyrics could not be used as evidence against Peterson. Nevertheless, the court stated, if your client testifies, I'll have to take it on a case-by-case basis. But essentially, anything pertaining to this case obviously is fair game. The error drastically prejudiced Peterson because it wrongfully induced him, it wrongfully induced him to waive his constitutional rights to present his version of events to allow the jury to see him as Daystar and not the violent person acting out the literal and grossly butchering of his accuser and painted by the people. That this error caused Peterson to surrender his constitutional right to testify in his own defense. So for all y'all that want to know why Tory didn't testify, there go your answer. Furthermore, despite the decision under People versus Collins, 1986, and Lewis versus United States, Peterson did not forfeit his claim of error because the Lewis-Collins rule does not apply here. Under the Lewis-Collins rule, a defendant forfeits his right to argue on appeal that his right to testify was violated if he did not testify at trial. However, the Lewis-Collins rule is distinguishable from the facts at issue because those cases involve the admissibility of a prior conviction for impeachment purposes. Significantly, in those cases, the court had ample discretion under 352 to determine the issue of admissibility. In the instant case, the evidence of creative expression is presumed to be minimal probative value unless the evidence passes the robust inquiry required under 352. Moreover, the rationale under the Lewis-Collins rule, the necessity of having the precise nature of defendant's testimony to weigh the probative value against its prejudicial effect to review for abuse of discretion does not apply here. Rather, the instant inquiry is subject to de novo review because the question is one of the law involving determination of applicable legal principles, the People versus Genovese in 2008. Therefore, the Collins-Luce rule does not require, under the facts of this case, that Peterson testified for the preservation purposes. Section 352.2 was applicable to the admission of the evidence of creative expression, yet the court applied the far less standard to define the evidence admissible. Venerable 88 Cal at 5th at P445, knowing that the standard under 352.2 makes it more likely that the evidence of creative expression will be excluded. As a result, the court deprived Peterson of the right to counsel's intelligent assistance on whether to exercise his right to testify or not testify and impaired his right to a fair trial. A sidebar conference was held with Peace testimony where the following exchange occurred. Ms. Ty, well, Tory was actually on a Florida Miami probationary term that started in 2017. He's opened his door by suggesting that he was not on probation at the time. We did not know when his probation expired, but he certainly began his probationary period in Miami in 2017. He very well could be on probation. Mr. McDyson, my client has never been on probation. My client got arrested in Miami, the case, but was never charged. He was never on probation. He never pled guilty, so he could not be on probation. Ms. Ty, we have an Instagram live video here where Tory talked about going to his probation officer. Ms. Ty, the docket said it was divisionary. This isn't an arrest in 2017. Mr. Bott, there's a certified DOJ rap sheet arrest for concealed weapon in a vehicle. He was put on diversion, and we talked about being on probation in a video. Ms. Ty, counsel says specifically Pete is lying about this probationary matter. But here's the thing. Tory has made statements he was on probation. Whether or not that is actually true, that is irrelevant. The fact that counsel asked Detective Stogner or not he was on probation to suggest Megan lied. Detective Stoner can probably say at minimum he didn't realize he might have been on probation at that point. Tory was ordered diversion for a gun possession in 2017. And then counsel proceeds to essentially open the door by questioning Detective Stogner about Tory's probationary status to suggest that somehow he could not have possibly been on probation or some type of supervision at that time. That completely opens the door. Counsel again clarified that the case was dismissed and that Peterson was never convicted in the Miami case. The court then ruled the facts of the incident are not what's an issue. The issue is whether or not he was on some type of court supervision. I would allow you to inquire that there was an incident in 2017. He was placed on court diversion. Don't mention what that arrest was for. Despite, what is this, protest? Despite protestations from counsel as to preserving the record, the court instead moved along. Ty was subsequently permitted to elicit testimony that Detective Stoner ran Peterson's rap sheet and discovered that he had a 2017 Florida criminal case that resulted in diversion. During cross-examination, counsel questioned Detective Stoner about the fact that Peterson had never been on probation. On redirect, prosecutors questioned Stoner on this issue. Question. And you don't know, obviously, whether or not he was still on diversion in 2018 or 2019 or 2020, correct? I can only speak on my experience with the diversion in California. So the specific details of Florida diversion, I'm unsure of. So those follow on years. Diversion could be whatever was agreed to by the court. Right. So he still could be on diversion in 2018, 19, and 20, correct? That is correct. This was reckless misrepresentation of the evidence. At a later sidebar, counsel informed that the court the people's paperwork showed that Peterson diversion was for 2 months and that the case was dropped in 2017 of April. Counsel further argued that the jury might misunderstood that and think that he may have been on diversion in 2020, even though he was not on diversion in 2018 or 2019. Instead of striking Detective Stoner's false testimony, the court instructed the parties to fashion some kind of stipulation. The final stipulation, which was read to the jury, stated that Tory was ordered a grant of diversion for a criminal case in 2017, and that diversion was terminated in April of 2017. In other words, despite having Peterson's docket prior to Detective Stoner's testimony, prosecutors made misrepresentation to the court and thus were unable and the court was thus able to introduce inadmissible evidence of Tory's previous arrest in another state for unrelated matter. Such evidence had no relevance whatsoever to the incident at issue, and Peterson was unfairly prejudiced by the portrayal of him as a criminal previously ordered to rectify his behavior. Man, they just screwed Tory so much crazy in this game. He was like, damn. He had somebody in that courtroom had the hookup. They were just straight sabotaging him. Well, I do say they got enough evidence here, or a strong enough argument to grant him an appeal. All right, I'm tired. I've been on here all day. I feel like today, butchering up words. But when his DNA wasn't present, he should have been acquitted. Not when you goddamn they doing all this slick way to get all this crazy testimony up in there and paint all this picture, and then he get up there and testify. Then they gonna use all his lyrics. Oh, he'll kill it. This he said he'd kill. He'll shoot somebody. This he said. Like he was damn if he do, damn if he didn't. They. It's crazy. Insubordination. I don't know, Tory. I think you got a great chance, but I'm halfway through it. It's still another 50-something pages, and I'm gonna get to it. But in the meantime, in between time, you do your thing, and I'm gonna do mine. All right? Choke no joke. I'll see y'all tomorrow, man. All right? I got a bunch of videos dropping. Be prepared. One love. Ladies, if you got that clean,
no joke.
put a
You
heart in the
already
chat.
know.
Y'all know I love that. Ladies, if you got that clean coochie, put a heart in the chat. All right? You got a clean coochie. Fellas, if your ladies got a clean coochie, put a heart in the chat. All right? Joke, no joke. Hit that subscribe button and that like before you get out of here, all right? One love. Joke, no joke. You already know. Y'all know I love that cooch. You know what this is. I love that cooch. Yeah. It's the A thing. Yes, we don't have no clean ones. Yo, what's up? My nuts when I wake up. Got more than wood and I just bust one. And mahogany, I'm Ron Isley. Between the sheets, and she want to ski. And just shout with me with what I thought was pee. She rolled the D, her water broke B. Not pregnant, but baptized me. I'm down for more love, but change the sheet. She said, please, I want more. Next thing I know, mattress dripping the floor from her juices. Oral had me stoned, had a Corinne and Medusa in one. And when I look in her eyes, between her thighs, I tell you no lie, ain't shit won't buy. I rob and take it, for me to taste it. Red Lobster, pussy, biscuit, freshly baked. Eat that coochie all night. She sprayed my face like Shook Sprite. I love her. I eat her coochie all night. She sprayed my face like Shook Sprite. I love her. Up my nuts when I wake up. Got more than wood and I just bust one. And mahogany, I'm Ron Isley. Between the sheets, and she want to ski. And just shout with me with what I thought was pee. She rolled the D, her water broke B. Not pregnant, but baptized me. I'm down for more love, but change the sheet. She said, please, I want more. Next thing I know, mattress dripping the floor from her juices. Oral had me stoned, had a Corinne and Medusa in one. And when I look in her eyes, between her thighs, I tell you no lie, ain't shit won't buy. I rob and take it, for me to taste it. Red Lobster, pussy, biscuit, freshly baked. Eat that coochie all night. She sprayed my face like Shook Sprite. I love her. I eat her coochie all night. She sprayed my face like Shook Sprite. I love her. Joke, no joke. Jack Brown. Yeah, now. Joke, no joke. Jack Brown. Yeah. This what ATL in New York sound like. Let's go. Y'all hating ass niggas, I see y'all. Show get busy, that's why I got the crown. Hate in the air. You clowns, I see the envy that you breed, jealousy. What you need is your own damn hustle. Stop worrying about mine. Nigga, I'm poppin' cause I put in time. Came out modeling, camera in hand. Still get busy with the mic in hand. Streets pulled out, niggas got sprayed. Niggas turn on you when they see you get paid. The intimidation in your face. Where's the love? What's taking place? You want my gold and my ducats, cause my money overflowing out of buckets. Shot him in public, made people holler. Scar on his face for the money and the power. I'm the chokester. Chokester. The truth in the industry made me the chokester. 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 The truth in the industry made me the game had me fooled, got in, was young. Thought talent made you rich, damn, was dumb. More to make, cake from crumbs. You gotta be sweet, G or native tongue. My heartbeat went into overload. When Larry tried to turn me into a mole, told me show my curly to the CEO. I didn't think it's funny, so his jaw hit the floor and grabbed that chair that broke his back.
Then realize that's a hate attack. Harassment comes assault, you in the maze. No way out, like Puff and Mace. Touch me, tease me, I catch a case. Nigga, you ain't straight as your poker face. Father law God, in that game I fold. This sun don't tick, demon time don't hold. I'm the chokester. Chokester. The truth in the industry made me the chokester. 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 The truth in the industry made me the chokester. Chokester. The truth in the industry made me the chokester. Chokester. On the ones and twos, chokester. What y'all want to do? I'm here now. Eden Wall, stand up. Shout out to the bomb squad.
Good night, Tasha Tanae. Good night to Lisa Renee. Good night, Cece. Y'all have a good night now. Much love. Make sure y'all kiss them babies good night. All right? Choke no joke. You know what it is. See y'all in the morning. All right? In the AM.